head note. A digest is which combines those head notes or summary of those judgments and puts their citation. So it gives you the section in the first that of this provision, all head notes or summary of that judgments in one go. This is the All India Hindu Law Digest. So all cases related to Hindu law with respect to each of its provisions, it has given just 2-3 lines of the summary of that judgment with respect to that section and the citation, so that you can go and take out that citation. We also have, each journal may also come up with their own publication of digest. Like this is the recent criminal reports, RCR, like I had said. This is the RCR digest, where inside, if you see, they have only the RCR citations and summary of each judgment under each section of that law. But this would contain only criminal law judgments passed by the High Courts and the Supreme Court. So certain example of it are, sorry ma'am, can we have the next slide please? So that is the RCR digest, CPJ digest and SCC digest. There are many more. Every journal will have their own digests. Can we have the next slide please? So I can only see journals. After journals is digest, which I have just concluded. And then there are manuals. Can you come to the slide which says manual? So manual, while they change the slide to manuals, I'll just explain it. Manuals is normally made by AIR, All India Reporters. Now, why All India Reporters makes a manual? It's very interesting. The AIR manuals contain the head notes of all the judgments of AIR. But interestingly, they also have, in addition, like a digest, in addition to that, they also have the Bare Act provision put there, the entire Bare Act of that section, and inside that, under that section, they have all judgments which were pertaining to that section and journaled in a All India report are put in this manual. So if you buy, when you become lawyers, when you buy this entire set of manuals, you must, first thing I think you all should purchase is a AIR manual. Reason being, the AIR manual contains all the central government acts which are alphabetically put from A to Z, and you get all the Bare Acts. Not only Bare Acts, you get the further head notes of each section, so it's easier for you to understand the interpretation of each section. So this is a more detailed. So once you have the complete AIR manual set, you are sorted, because you don't need any other Bare Act to be purchased from time to time separately. You got a list of all in case of emergency. The reason why you need to keep buying Bare Acts is because the amendments keep coming. This would not have the amended, the manual will not have the amended provisions. So only for that reason you may have to buy the respective Bare Acts. Next slide please. Now these you've understood what are the kind of books that are there in the law library and how to do your research to reach those judgments, and then how to read the judgment by which we had started. But now let us understand, and I'll keep it short here, what are the type of cases in the courts. Of course, there are various variety. I've just summarized it to make it more simpler. Now, first, the basic and foremost are suits. Suits in a civil case are filed. Now, interestingly, there are certain high courts, not all high courts, there are certain high courts in our country which have an original pecuniary jurisdiction. Say, for example, in Delhi, if the value of the suit is more than 2 crores, the suit is to be filed directly before the Honorable High Court of Delhi. But that is not the case in every state. Say, for example, in Haryana or Punjab, if your suit is worth multi-billion crores, it doesn't matter. you will still have to go to the district court. It may be 20 crores, 200 crores, 2000 crores. It will first go to the district court because the Punjab Haryana High Court does not have a original pecuniary jurisdiction, unlike Delhi. So that's different from court to court. So suits can, in certain high courts, file directly in high court. Otherwise, it's in district court for sure. Then is an appeal. Appeal against a suit under section 96. You can file an appeal if the suit is decided and you do not like the judgment passed there. You can appeal against it. In certain cases, only where the question of law is involved, section 100 says you can appeal for a second time. But second appeal is very, very limited, only restricted to the question of law. Then in the high courts, you have seen, it's very common for you to have heard of writ petitions under Article 226. And there are, of course, 227 also, where writs are filed. Article 226 writs are normally concerned with your fundamental rights and those kind of things. 227 is the jurisdiction over the other courts, the tribunals. So supposing I have an order against the Central Administrative Tribunal, I may choose to appeal against it, but there is no appeal lying against it. So I'll have to, instead of an appeal, I'll file a writ petition under Article 227 before the Honorable High Court. That will be heard by a single judge. Certain writs also heard by a single judge. And if that single judge passes a decision which I wish to appeal, I need not necessarily go straight to the Supreme Court in SLP. I may file an LPA, which is also Letters Patent Appeal, which will be heard by a larger bench against the decision in that writ. So appeals against writs are called LPAs. Then of course in Supreme Court there are different kind of terminologies used when we file a case. Normally any challenge of an order of a high court, we will go to Supreme Court by way of a SLP, which is a special leave petition under Article 136. Now what is a special leave petition? In a special leave petition, we basically seek the leave, a special leave of the Honorable Supreme Court to file an appeal or to convert that as an appeal. So if your SLP is decided and the Supreme Court feels that yes, it needs to be heard in detail, it will convert that petition under as an appeal. Now why that difference? In fact, my associate Pooja told me about this today morning itself. And very interesting, even I didn't know this. That an SLP is a provision under the Constitution of India, under Article 136. So, Supreme Court, when you go using the Constitution of India by way of a special leave petition. But if the court decides to hear it as an appeal and converts it into a civil appeal or a criminal appeal, the reason why it needs to convert is because once the moment it becomes a civil or a civil appeal, it will automatically be following the rules applicable under the Code of Civil Procedure, or in case of a criminal appeal, then it would be the rules under the Code of Criminal Procedure. Supreme Court has also one very interesting aspect, which is there of course in the High Court under Article 226. The writ jurisdiction of the Supreme Court is under Article 32 of the Constitution of India. We then have the review petitions. So supposing a case is decided in the Supreme Court, you're not very happy with the order, that is the apex court. Where do you go? First and foremost, you go back to the same judge. Of course, very limited scope under Article 137 by way of a review petition, where you ask the court to relook into the decision passed in your case. And in case the judge chooses not to hear or not to allow your review or does not make any change, you have one last option, and that is the curative petition. Again, very, very sparingly used and very restricted. In fact, there is no provision under the Constitution for a curative. It was first decided under the Ashok Hura case in 2002. So these are the Supreme Court and the High Court the cases which come up before the High Court and the Supreme Court. And of course, Supreme Court is the court of record, so all the judgments passed by the Supreme Court and High Court in certain matters get carried away in the journals, like I showed you how to read those journals, and that is why they are also called the court of record. Next slide, please. Now that you've understood the various aspects of judgment, the kind of cases in various courts, let us understand what constitutes precedence. And not every judgment becomes a precedent. It's very interesting here. Can we have the next slide, please? So when you look at a judgment, certain judgments, we divide them into certain aspects. I'll show you when the slide changes to a slide called precedents. That's the next slide. And precedents are very interesting. Everybody's heard of precedents. We always, when we go to a court and we are arguing a case, we always take up a judgment of the High Court and the Supreme Court and say, see, this case, this issue has already become a precedent in so and so matter. So that's how we are quoting it. So, but all judgments, or all part of the judgment does not become a precedent. Can we have the next slide, please? There are certain things in a judgment or certain part of a judgment which we call the ratio decidendi. Then there are certain parts which we call the obiter dictum. These are certain ways of the court. There's also terminology called stare decisis, which is there under Article 141 of the Constitution. And of course, another terminology used is per inquirium. I'll one by one explain what they are. Now, ratio decidendi and obiter dictum are of course explained in the case of Carlyle versus carbolic smoke ball. A ratio decidendi is basically finally what the ratio the court decides upon. That ratio, supposing the court feels that so and so is finally what it feels should become the law, that would become the ratio which it has now laid down or decided the case upon. So that is ratio decidendi. Then there's something called an obiter dictum. Obiter dictum is basically where a court may give an example to make it clear as to why or what is the reason behind passing of that judgment, but it is not ratio decidendi. That again I'll show you by an example in the same case. That is an obiter dictum. Though it forms as an opinion of the court, it comes as an example of a court, but it cannot be taken as a precedent. Only the ratio decidendi becomes a precedent. Then there is stare decisis, Article 141, and per inquirium. So I'll come one by one. Let us come to this very interesting case of Carlyle versus carbolic. Can we have the next slide, please? So what happens in this case is very interesting, is that a company offered by way of an advertisement to pay rupees 1 lakh to anyone who contracts the increasing epidemic influenza, cold or any diseases caused by taking its medicine. So the reason behind this was, at that period, the phase in life, there were a lot of these diseases coming in, and it had challenged that anybody who takes this medicine of theirs, they will not have any of epidemics like influenza, cold or any diseases caused by these things if you take the medicine. Now, to assert their authority over it and make people believe in it, they advertise that, listen, anybody, if they come after taking the medicine, it's a challenge, nobody will suffer any influenza or cold, but if they do, we will give them 1 lakh rupees. So they use the medicine according to the printed directions. There was one person, one lady, Carlyle, and finally when they had this 1 lakh rupees, which they, in fact, part of it, they've said 1 lakh rupees we are depositing in the bank to make it confirmed. We will give this money in case we suffer, anybody suffers influenza after taking this medicine. They said we'll give this, but somehow this lady, Carlil, after taking the medicine, she thought she's safe. Like nowadays, a lot of people are taking the COVID medicines as precautions. And tomorrow, if they suffer COVID, though in India nobody is given, no company has given that assurance that they'll give you 1 lakh rupees. But in this case, they did. It's an actual real case. But when this lady actually suffered influenza, even after taking the medicine, they stopped. They said, sorry, we are not going to give you the 1 lakh rupees because there was no contract between me and you. You never signed. For a contract to come into existence, there has to be an offer, there has to be an acceptance, and there has to be a consideration. But in this case, there was none with that lady and the company, so they refused to, or they give that 1 lakh rupees on this ground. On the next slide, can we have the next slide, please? Now, while passing this judgment, the court gave another example. And that example could not be used as for citing as a precedent. And that is why it is called the arbiter dicta. So the arbiter dicta, we have just written that just for your reference as to what constitutes an arbiter dicta. So the example given by the court while passing the decision here, it said that if I advertise to the world, that's what the judgment said, if I advertise to the world that my dog is lost, and that anybody who brings the dog to a particular place will be paid some money, and all the police or other persons who are in the business of finding lost dogs expected to sit down and write me a note saying that they've accepted my proposal. No. Of course, they at once look after the dog, and as soon as they find the dog, they have performed the condition. The essence of the transaction is that dog should be found. And it is not necessary that under such circumstances, as it seems to me, that in order to make a contract binding, there should be any notification of acceptance. So, giving this example, the court finally went in favor of the plaintiff. But in case there is some other matter which comes up as an example of a dog being lost, could they have used this judgment as a precedent? No. This was just an example here, and that is why this example we call it a arbiter dicta and not a precedence or not a ratio decidendi. But what becomes a ratio decidendi? After giving this example, the court held that advertisement was an offer intended to be acted upon, and when accepted and the condition performed, it constituted a binding promise on which an action would lie, assuming that there was a consideration for that promise. Now, same thing, but now the court has laid down its mind, and this becomes a ratio decidendi which can be used as a precedent in other cases. So, thank you everyone. I hope you understood what are the parts of a judgment, what constitutes a judgment, and how to find judgments. I hope that would summarize everything that you need to know about judgments. Thank you so much. We have 10 minutes. If somebody has some questions, we can take that up.
Right. I may ask all the attendees if they have any questions. They may kindly put that on the chat so that a resource person can address those questions. As I can see, the Q&A is already there. There is so there is a question. Can I go with the first
Ratio decidendi and arbiter dicta.
Yes, I'm looking at a lot of questions. I'm just
And orbiter can be
going at
used
the
as a
top so that
precedence.
we can start. What happened in Ashok versus Hurra? That is the first question.
See, concept of curative petition was first decided there. And that's what I said. I don't know whether you heard it at that time. But curative petitions came into existence with that judgment. So where the court said that, okay, if you find there is a still an error which can be looked upon, which has been missed out even in review, you can come back because this is an apex court and we have to give at least one last opportunity, provided you are able to show to us that it was something very important which has been missed for some reason. Yes.
The next question is, can students use AIR manuals?
Of course, you can use for what purpose I don't know, but everybody should use AIR manuals. In fact, like I said, AIR manuals is a set of I think about 30-40 books, uh, bound books, which contains all the central government bare acts. So it will, at least for emergencies, you will have all the bare acts at hand with you all the time. And then, of course, in addition to just the contents of the bare acts, it has in detail the summary or the citations or the head notes which support that or explain that section or provision of law. So you must, I think everybody should have, my only students.
Okay. The next question is, what is the stare decisis?
I had explained stare decisis, but stare decisis, sorry, I was to explain it. I think I missed it there. Good. Thank you for reminding. Now, see, stare decisis is basically where Article 141 of the Constitution, which says that all judgments of the Supreme Court will be used as a precedence by other courts. So they make it binding on all other courts. That's Article 141, and that is called stare decisis. It's a decision which all courts below Supreme Court will have to accept it.
The next question is, can you please repeat curative petition and SLP?
The entire thing again, but I'll summarize it. See, what happens is special petition. SLP is a special leave petition. Any judgment of the High Court, when you go to the Supreme Court, you can go to the Supreme Court only by way of a SLP. I'm not talking about writ petition. You can always file a direct writ petition under Article 32. But if you're going against a judgment of a High Court, of any High Court, you will have to go by way of a special leave petition. That is a SLP, where you crave the leave of the court, a special leave of the court to appeal and appeal against that order. So if the Supreme Court finds that your case is fit to be heard as an appeal, it will allow your SLP and convert it into an appeal.
Next question
Yes,
is, can obiter dictum be used as a precedent?
I mean, that's what I said. It's a non-binding portion of the judgment. See, it's an observation of the court. It's not binding. It's like I gave you that example. It cannot be used as a precedent. In fact, I had mentioned that in the judgment itself. The judgment of Carlyle and Carbolic, where I gave an example, I clearly mentioned what was an obiter dicta. It was an example quoted by the judge to explain why he's passing that decision. So yes, it definitely cannot be used as a precedent. Ratio decidendi. I think a lot of people are still not clear about ratio decidendi and obiter dictum. Let me. What do I do? I've given an example. Should I give that example? Should I open the slide so that you can go through that judgment?
Sir, I think that you can just briefly explain the concept, and we will be sharing the reading materials with the students.
So supposing in a case where the judge holds that, see, in this case what had happened was there was a contract, or say for example a company, to prove its bona fide, comes up with a vaccination. If you take my vaccination, say it's Covishield, So it's you take Covishield, and Covishield pharmaceutical companies say that you take Covishield and I guarantee you nobody will have COVID if you are vaccinated with Covishield. To build its authenticity, say for example, the Covishield company says that I will, in case you still contract COVID, I will give you 1 lakh rupees. So people trusting that will start taking more of Covishield instead of Covaxin. Towards the end, what will happen? In case somebody finally suffers COVID despite having the vaccination, that person goes to Covishield company and says, listen, I had given you, you had promised to give me 1 lakh rupees. I've suffered because of you. Please give me 1 lakh rupees. What happens? The company says, sorry, there was no binding contract. So now, judge, while deciding this case, says that Covishield company was wrong. And it gives an example. Say for example, if a dog is lost and the owner says that, listen, if the dog is found, I'll give, whoever finds the dog for me, I'll give you 1 lakh rupees. And everybody starts searching for the dog. When you find the dog, it doesn't mean that just because it was not expected that every dog finder would start putting a consent or an acceptance to this proposal. The very act of finding the dog and bringing it to the owner shows that the contract was completed. So the owner will be liable to pay. This is an example the judge gave to satisfy that Covishield case. This example in itself becomes arbiter dicta. And now the court says, raise down the ratio that in such cases, if the advertisement was an offer which intended to be acted upon, and if it gets acted upon, it becomes binding. This ratio, this line will become ratio decidendi. That is the final observation which will be used as a precedent. And that story of that dog, which was taken as an example to decide this Covishield case, will become arbiter dicta, which is just an example, not to be used as a precedent. I hope I'm clear now.
I request all the participants that you may have come across a poll question that has been prompted by the organizers. I request all of you to answer the same so that it will be counted as part of your evaluation as well. So apart from that, we'll move to the next question. Just give me 1 second, sir.
It's already 7 o'clock, so I'll take just one more last question.
Sure, sir, sure. Can you please shortly explain per incurium?
So where a court relies upon judgment, so normally what happens is the courts rely upon precedents, it relies upon a certain provision of law, and then a statutory provision of an earlier judgment that would be relevant, and then passes a judgment. That's how it's passed, and that's how it becomes the stare decisis comes into play, because it has been relied upon and it has gone in a certain manner. Supreme Court decisions are binding upon all the courts, but supposing Supreme Court passes a judgment, and there are a lot of times when Supreme Court passes a decision which is based purely on facts, it does not rely upon any statutory provision of an earlier judgment or a precedent. It does not get into the depth of a certain provision of law. It's purely on facts or for some reason. Then it's called per inquirium. So it's an exception to a stare decisis. A stare decisis where all judgments of the Supreme Court are binding. The exception is a per inquirium judgment, which is not based on the precedents or any statutory provision. Those judgments are not binding. So per inquirium, basically those judgments passed by the Supreme Court, which are an exception to the fact that all judgments are binding. Or should I say, per inquirium are those judgments which are not binding, even if they are of the Supreme Court.
Thank you, sir. Sir, would it be possible for you to take any more questions, or should we just...
I would only want to clarify, has anybody, this is a slightly technical thing, has everybody understood per inquirium, or should I explain it once more?
students, you may kindly
I hope I'm
put
clear.
your inputs on the chat box. However, I cannot see any questions in relation to per inquirium. So I think
It's clear.
understood. Please explain once more. It's
It's
clear.
clear.
Done. I think there are multiple opinions. Some students
See,
are very clear
so
that
I just last time I'll explain this and then I think we'll conclude. So like I said, there's something called stare decisis. Stare decisis says, and that is Article 141 of the Constitution, where all judgments passed by the Supreme Court are binding on the lower courts. Stare decisis is clear. Can you please answer that one by one so that I go step by step by asking you questions? Everybody's clear with stare decisis. Great. So now stare decisis is that all judgments passed by the Supreme Court will be binding on all lower courts, high courts, everyone. And that is Article 141. Very clear. Now there's an exception to it. Though Article 141 says all judgments of the Supreme Court will be binding, it also clearly mentions that all judgments which are per inquirium will not be binding. Now, why per inquirium judgments will not be binding? What is per inquirium? Per inquirium is those judgments which have not relied upon a precedence or a certain provision of law, or it has not even gone to the legal aspects, purely based on facts. Those are an exception because they are bound to the facts of that particular case. In fact, Supreme Court in certain matters make it clear that this judgment being passed will not be binding on similar, will not create a precedence. Supreme Court itself says that. So those are exceptions, even to exceptions to Article 1, exceptions to Article 141, which clearly says all judgments are binding except these judgments, and those judgments are called per inquirium. Now is it clear? Per inquirium and stare decisis.
I think you have explained it very well, sir. I don't think anyone can explain it any better than this. On this note, unfortunately, we have already reached the end of this workshop, and sir has to take our leave because he has some other engagements. I hope this has been a very learning session for every single one of you. For all of those who still have a lot of questions, you can share your questions on the WhatsApp groups that we have created, and we'll be more than happy to answer all those questions. And thanks a lot, sir, for taking out your invaluable time today. I know it's been very difficult for you to take out this hour for us, but I'm sure all the students and including myself, we really appreciate your time and effort. So thank you so much for joining us today, sir.
Thank you so much. Thank you.
Yes, sir. Thank you. In conclusion, this is for all the students. Every single one of you who wants to get a certification for this particular workshop with LEDX, I request you to kindly fill in the feedback forms that you will be receiving after this session, because on the basis of those feedback forms, you will be receiving your certificates, the reading material of the course, as well as the PPTs that have been shared by sir. In addition to that, LEDX is also organizing a boot camp on conflict resolution, mediation, and client counseling on the 20th of May. As you have attended this particular free session with us, you will be receiving a discount coupon of 50%. The costing of the bootcamp is very nominal. It's only rupees 500. And those of you who will be joining us for that bootcamp and who have attended this workshop will be getting a discount coupon of 50%. So you will only be paying half of what is the registration amount. So I hope to see many of you in that session as well. Rest assured, it's a 9-hour long session for 3 days. You will get a lot to learn, and I'm sure you will have a wonderful experience with us again. On that note, I bid you all adieu, and I hope you had a great learning experience with LEDX. Thank you so much.